Good morning, ladies and gentlemen, and a very warm welcome to this Quadrant Shipping Review 2023. My name's Simon Rainey KC, and I'm very pleased and proud to chair so distinguished a panel of members of Chambers, all heavyweight hitters. You'll see that the panel doesn't look very diverse this morning, pale and male. I will leave out the other adjective. The reason for that is, unfortunately, that Gemma Morgan, who was due to be speaking with us today, has gone down with something rather nasty, so she's unable to come. But we're very lucky at the last moment that Paul Toms has stepped in to deliver her a talk on her subject. This is almost a historic moment, ladies and gentlemen. This is the last time, or one of the last times, you'll see Paul Toms as mere Paul Toms, because Paul Toms is taking silk, and when the Ministry of Justice actually decides on a date when that ceremony will take place, he will change into Paul Toms KC. We'll have questions at the end, and if anybody asks a question, can they please raise their hand? We've got a travelling mic that can be brought to you. As you'll see from the introduction and invitation, we're covering 5 topics this morning. We're going to take them in a slightly different order from the order in which they're set out in the invitation. Our first topic is one which is on everybody's lips, and many people in this room will have been busy with the problems which it has thrown up since the end of 2023. I know that we on the panel have been. And that's the Red Sea and the Houthi attacks on shipping and the consequent throttling of Suez Canal transits. Our speaker is Nigel Cooper KC, about whom, and being chairman, I can get all these embarrassing quotes from the directories, about whom it is said, a class act, intellectually sharp and quick on his feet. That means that he'll be very, very happy indeed to welcome questions at the end. You can direct them all to him. Nigel, are standard Charter Party war clauses really fit for purpose?
Well, thank you, Simon. I think that is such a sensitive question. That are they fit for purpose? The difficulty, I think, remains, as I'll come to in a moment, that it is difficult to know, still difficult to know, depending on the wider terms of the Charter Party, whether or not an owner is actually going to be able to make use of those clauses. What are the risks actually present in the area? What are the risks that the owner has agreed to bear? But those are themes I want to come back to, because as many of you will know, the present difficulties in the Red Sea and surrounding area were the subject of a Quadrant seminar just back on the 16th of January. And I'm asked to emphasise that it is now available on our YouTube channel. And so you might ask, why are we revisiting the theme today? Well, first of all, there were a number of questions following the event which there was not time to answer. Secondly, the situation in the Red Sea continues to be volatile. More questions are arising. Indeed, answers to some of the questions previously given may have changed. And then thirdly, and of course, well, not finally, but to add to the mix, the Supreme Court has now delivered judgment in the Polar on the 17th of January. Now, that case, as you will be aware, concerned the question of when owners are entitled to recover the costs of negotiating and the costs of paying ransom to pirates as part of GA. And the case concerned claims made against cargo interests in GA, in respect of which the cargo interests argued, first of all, that the insurance provisions within the Charter Party represented a complete code and therefore addressed the question of who was to bear responsibility for GA, and also turned to the question, sought to argue that in any event this was a risk. The risk of piracy was one that owners had agreed to bear in any event. Now, it's not my plan today to steal Guy Blackwood's thunder. Guy, as you're probably all aware, led for the successful owners in the Supreme Court and will no doubt be available to answer questions at seminars coming up in the near future when he can explain the judgment in more detail. But I wanted just to touch on one of the themes that seems to me does become central to a number of the questions that arise in the Red Sea context. And that is the extent that, going back to your opening question, Simon, the extent to which there is a conflict between the provisions of specific war clauses, such as Con War Time 2013 and Voy War 2013, and the wider trading terms of the Charter Party. The question being, essentially, to what extent can owners or the master refuse to transit the Gulf of Aden or the Red Sea under specific war risk provisions if the Charter Party expressly includes those areas within the trading limits of the Charter Party, or specifically provides for the transit of the Suez Canal in certain circumstances, such as, again, against, for example, charterers agreeing to bear the cost of additional insurance premiums in any event. Now, you'll probably all groan when I take the traditional counsel's cop-out of saying, well, it depends on the construction of the terms of the Charter Party, and it's a very fact-sensitive question. But actually, that is very much the case in the context of questions surrounding the rights, the obligation to transit the Suez Canal at the moment and to transit the Red Sea. You have a wide-ranging variety of contractual terms that may impact on the effect of the war risk clauses. And for example, in the Polar, that of course concerned a voyage charter. And that in itself is interesting because as the Supreme Court highlighted, I think that was the first case concerning a voyage charter, whereas the other cases that are relevant to this type of issue principally concern time charters or time charter trips with differing underlying obligations. And the Supreme Court in the Polar was fairly easily able to accept that if a relevant charter is a voyage charter, providing for a voyage via the Red Sea through the Suez Canal, or for transit between or for a voyage between two ports where it is inevitable that you're going to have to transit the Red Sea or the Suez Canal, or perhaps usually would, then the owner is very likely to be held to have accepted the risks of that passage that were known at the time of the charter, particularly if there's provision for payment by the charterer of any additional war risk premium. The position becomes more difficult if the trading terms are more general. And you can see that if you look at some of the earlier cases concerning time charters, where you've got, for example, I think it's in the Paiwan Wisdom or the Triton Lark, where there were specific provisions allowing, where owners were agreeing to transit the Suez Canal and therefore transit the Red Sea, Gulf of Aden. But what if the position is rather more general? If simply there are wide-ranging trading limits, which include an allowance that the vessel will pass through the Red Sea, will transit the Suez Canal, or if it's a time charter rather than a period time charter rather than a time charter trip. Now, once the trading terms start becoming rather more general in that regard, then it is going to be easier for the owner to say, well, yes, I agreed trading limits that allowed the vessel to transit Suez, but I wasn't thereby specifically agreeing that I would accept known risks as at the time of the charter. There is no specific agreement on my part to bear those risks. The obvious other provisions that one is going to have to look at are the insurance provisions. Yes, a number of the cases, for example, I think it's the Paiwan Wisdom, there was a specific agreement on the part of on the part of owners that they would transit if provided charterers were paying the additional premium. Now, again, that is a strong indicator that in those circumstances, it can be said the owner has agreed to bear the risks known at the time of the charter party of entering the regions, the waters leading to the Suez Canal. So that's perhaps one of the starting points in terms of determining whether or not, even if you've got Voy War or Con War in your charter party, owners have agreed to bear the risks of transiting the Red Sea. Now, one of the arguments is perhaps interesting to turn back and reflect on that was raised in the Polar, but was rejected by the Supreme Court, was that it was said, well, that an analogy was raised with safe port principles, namely that it's not inconsistent for a charter party to provide for both a voyage or a trip between named ports and a warranty of safety. And the analogy that was being drawn was that you could have a scenario where the charterer was agreeing, this was put forward by cargo interests to support their case on assumption of risk. And they were seeking to say that clearly, if you can have a situation, it's put forward by owners to say, well, even if we have agreed to transit between named ports, or if we have agreed to transit the Suez Canal, the charterers are still to be taken as giving a warranty of safety in circumstances where there are war risk clauses. That analogy, the Supreme Court has rejected. They have said, no, there is no similar analogy. What we're dealing with here is a different scenario. The risks of piracy, war risks are different from the principles to apply in the context of safe port. And therefore, that doesn't help in determining whether or not, it doesn't help owners in putting aside the question of whether or not they've agreed to bear certain risks. So that takes us then on to what are the risks that owners have agreed to bear. There was some uncertainty in the case law surrounding Conwar time and buoy war as to whether or not those clauses by themselves required an owner to show that if they wanted to rely on them, there had been an escalation of risk. Now, that uncertainty was put to bed in the Pylon Wisdom, but as TJ emphasised in that case and in the Triton Lark, one has to look at the contracts as a whole to determine what risks the owner has agreed to bear as at the date of the charter. And that question is separate to further questions that have to be asked if an owner or master is going to refuse orders to enter the Red Sea as to transit the Suez Canal. Namely, is the refusal reasonable and is the owner acting in good faith? And certainly I've seen cases where, in recent weeks, where the allegation being made by the charterer is that the owner is simply relying on the news of the Houthi attacks as an attempt to divert around the Cape of Good Hope and earn extra money that they wouldn't otherwise be entitled to earn under the charter. So in answering both of those questions, and again it's worth emphasising that the Polar has confirmed that these are questions relevant to assessing whether an owner is entitled to refuse orders. What does the owner have to show? Well, first of all, they have to establish that the risks in question are relevant to the particular vessel. So that's going to mean looking at, for example, changing public statements as to which vessels are risks and whether or not that information is accurate. And that's one of the difficulties at the present time, that what statements the Houthis put out don't necessarily bear resemblance to what they're actually doing. And they're also going to have to show what did they do to determine whether or not to refuse the orders to transit the canal. And one of the points that was made in the Pylon Wisdom is that there was no evidence that the owners had talked to the master before making their decision. No evidence of local advice being sought. And again, questions will arise as to what internal discussions have taken place, what correspondence is there, what risk assessments were done, what alternatives were considered. Although, as one owner put it recently, armed guards aren't very much used against missiles. So I'm very conscious, Simon, that time is running and that you're already ticking your watch face at me. So I apologise for how swiftly I have dealt with this, but that, in a sense, ladies and gentlemen, is a very swift run-through in respect to which I'm happy to answer further questions as to the impact of the Polar Star on the current discussion about war risk clauses and how effective they are.
Just one last minute, if I can trouble you. Do you find there's an issue with clauses that are dealing with the safety of the port to which the ship is going, rather than the places through which the vessel has to pass to get there? Because with the Red Sea, yes, it's a bottleneck for Suez transits, but there's another way around.
There's another way around, and there's also perhaps the wider question as to whether or not the approach through the Suez, the transit through the Red Sea, forms part of the approaches to the port or not. Because, of course, the traditional doctrines that surround the safe port, the test for whether or not a port is safe, applies not only to the port but also to the approaches. However, it seems to me that, depending on the terms of the Charter, one is going to struggle to say that the Red Sea is an approach to Rotterdam, Singapore, or wherever it may be. Yeah. So I'm not sure that clauses dealing solely with the port are going to be of any particular use.
Yeah, thank you very much. Well, ladies and gentlemen, we'll be very pleased after these talks are finished to have questions, but also any views from people about whether current fixtures which are being negotiated are actually changing their terms in some way by rider clauses to respond to the current crisis. That would be very interesting to know. And as Nigel said, please don't forget to watch, if you haven't seen it already, the Quadrant Chambers special webinar on the Red Sea. It's an hour long, it's available online, it's extremely informative and very useful. Our next topic is another fact of modern shipping life, and one that gets more and more involved with every week that passes, as the net widens for designated entities and their creatures, and its sanctions. Chris Smith KC, about whom it is said that he is robust, clear, concise and polished, is going to guide us through the latest Court of Appeal decision in the area, last year's decision of the Court of Appeal in PJSC and Mints, which ruffled quite a few feathers after a very throwaway remark by Lord Justice Flo at the end as to President Putin controlling absolutely everything. So, Chris, where are we now on control, and what is the test that the Court of Appeal has helped us with, or not helped us with?
Well, that's the big issue that everyone was concerned with after Mints. Lots of ink has been spilled on that particular point when Lord Justice Flo made the point that Putin controls Russia much in the same way that Poonam controls our chambers. Absolute command over every aspect of it.
We do her will.
And that's something, there has been an update on that, and I'm going to touch on that. But as I alluded to, whilst that is something on which there's been a sharp intake of breath and a lot of discussion, it was also actually the tail end of the case. It was the overture, it was a remark at the end of the case, and there's been much less focus on what was actually the ratio, the main issue in that case. The main issue in Mints was the question of whether or not it's a breach of the sanctions regime to pursue a claim on behalf of a designated entity and to enter judgment in favour of a designated entity. And obviously those are all super important points because we may be instructed by designated entities, we may kind of already have cases on behalf of them. And if you can't actually proceed to judgment, then, well, what's the point? Even if you can get a licence from OFSI saying, yes, it's fine to accept money for them in return for legal services, if you can't get the end result, well, you might as well stop now. So that was the main issue in Mints. And the Court of Appeal judgment is very interesting on this. So they started by saying that the UK sanctions regime must be construed consistently with the EU sanctions regulation. Now, the language of the two regulations is actually very different. And normally that would, as an advocate, is a bit of a gift. You say, well, hang on a second, they've used different language, ergo they must have a different meaning. And the court dealt with that quite pragmatically. They said, no, the intention was consistency between the two. The fact that they've used different language was just a practical reflection of life after Brexit. No UK government wanted to be seen slavishly adopting the words of an EU regulation. So that was the reason for the different language, they said. Now, obviously that's important because that means now, firstly, you can look to the EU regulation as an aid to construction of the UK one, and also means you can look to EU decisions as an aid to construction if the intention is the same. So they started with that, and that was important because under the EU regulation, I think it's Article 7, that there's a provision that says it's permissible to pay into a frozen account sums pursuant to a judicial decision. And the Court of Appeal started their observations by saying, well, if you can actually have a judgment entered and payment made, then how can it be a breach of the regulation to actually get in that position, to pursue proceedings which allows you to enter judgment? So that was like a starting observation which gave a pretty good clue as to what their thinking was at the point. But then obviously they had to deal with the nuts and bolts of what the UK regulation actually said. And to recap, the UK regulation, Regulation 11, it prohibits dealings with funds and economic resources. Regulation 12, it prohibits making funds available to designated people. And that was where the argument centred. The court started by saying that a cause of action is not a fund for the purposes of the regulations, but it is an economic resource. Now, the reason why that was an important distinction is twofold. Firstly, under Regulation 12, the provision that says you can't make available something to a designated person, that only applies to funds and not economic resources. So that automatically took the case outside of Regulation 12. The other reason it was important is that under Regulation 11, whilst that says that you can't deal with both funds and economic resources, the test for what constitutes dealing with is different. The categories of behaviour which constitutes dealing with a fund is much broader than the categories of behaviour that constitute dealing with an economic resource. So defining that it wasn't a cause of action was not a fund was important for these purposes. But they did say that it was an economic resource. In the context of that, the court went on to say that, well, clearly, whether or not it's a fund or an economic resource, pursuing proceedings in themselves can't be a breach of the sanctions. So there's no question of a lawyer who institutes proceedings, makes closing submissions, in those circumstances, making funds or resources available or dealing with them, so on and so forth. That's fine. So we're all got to the question of whether or not the entry of judgment crossed some sort of line. And it was held that no, it didn't cross some sort of line. Whilst, obviously, a judgment in itself can constitute an economic resource and can constitute a fund, the entry of a judgment did not amount to dealing with the fund. It created, in one sense, the fund. And the language of Regulation 11 made it clear that the relevant dealing with presupposed that you were dealing with an already existing asset or fund. Here, where the judgment takes the cause of action, effectively destroys it by the doctrine of merger, and creates a new one, that does not amount to dealing with a fund, and therefore it's all clear. The next question was whether or not it amounted to dealing with an economic resource. And the definition of dealing with an economic resource makes it clear that what you're talking about, or what's being prohibited, is something where you're exchanging an economic resource for something else. And again, because of the doctrine of merger, they said, well, there's no exchange there. Something's being destroyed and something else being created, but that can't be regarded as something changing hands, so to speak. And so, for those reasons, the Court of Appeal held that pursuing proceedings and entering judgment in favour of a designated person was not in breach of either Regulations 11 or 12. The court also went on to hold that even if they were wrong about this, and you can't enter a monetary judgment, what was very clear is that there was no way the regulations could prohibit the entering of a declaratory judgment. So they said, obviously with an eye on potentially the point going further, though it doesn't appear to be, that, okay, if we're wrong and you can't enter judgment, the court can do everything short of that. It can enter a declaratory judgment and declaratory relief, and then wait for sanctions to be lifted and see if that can be translated to a monetary judgment. So that's an important decision, just the ratio, even though there's been much less commentary on it, because it means we can actually all act on behalf of designated entities, or at least if we are a defendant to a claim by a designated entity, we can't use the sanctions to stop it in its tracks, which is effectively what the defendant was trying to do in the Mintz case. If you can get a licence from OFSI to receive the funds from a designated entity, you can pursue a claim on their behalf. Now, the decision in Mintz concerned court proceedings, whether or not you could get a judgment of the court. That raises the question, which I'm sure will be of quite a bit of interest to various people in this room, about whether or not it also applies to arbitration proceedings and arbitration awards. Can tribunals be safe on the back of the judgment in Mintz to think, okay, fine, entering judgment's fine, therefore the rendering of an arbitral award is also fine? Well, the slight bad news for you is it's an open question. The Court of Appeal's judgment was limited very much to the question of proceedings. However, and I don't think about it's an open question, if I was being asked to express a view in front of you good people, I would say that the reasoning in the Court of Appeal does apply to arbitral awards. If you think about the brief summary I've given, lots of the points that the Court of Appeal made don't depend on the fact that it was in the context of court proceedings. Is a cause of action a fund? Well, the answer to that should be the same whether or not you're pursuing court proceedings or whether or not you're pursuing arbitration proceedings. Ditto the points about merger, which applies equally in arbitration, and the fact that that does not constitute making a fund available. It's creating something which previously didn't exist. So a lot of the reasoning of the court would apply equally to arbitration. I would also note that Mrs. Justice Cockrell, at first instance, there's one paragraph of her judgment where she says that she thinks the intention was probably to have the same rules for arbitration and court. So it's probably okay for arbitration awards, but that is an open question. It's not been definitively decided. So yes, arbitrators can perhaps breathe a sigh of relief in that regard.
So Chris, I just wanted to sort of step in here and go back to your point at the beginning about the obiter from Lord Justice Flo that created all the furore. Is that the final word, or have the courts already come back to look at the impact of his thoughts?
Well, there has been one judgment which has expressly commented on it. It's a case called Latasco and Demond, where Mr. Justice Foxton looked at the Court of Appeal's judgment and very carefully, very skillfully, Mr. Justice Foxton made it clear that he didn't agree with the judgment, or at least didn't agree with the common understanding of the judgment. What he said in that case was, well, the facts before the Court of Appeal, the relevant bank was clearly under the de facto control of Putin. And Mr. Justice Foxton said, well, the language of Lord Justice Flo was in quite tentative terms and was made very much in that context. And so with that springboard for effectively reaching a different decision, Mr. Justice Foxton said, well, on the control issue, it's not enough that Putin is capable of calling the shots of any company in Russia. He has to, in fact, be calling the shots. So if you're in a case where Putin is actually in control, de facto control, like in Minsk, then what the Court of Appeal says applies in its full effect. However, if it's just a situation where you're a Russian company, Putin doesn't even know you exist, and has never done anything to exert any control over it, then, according to Latasco, that falls outside the definition of control. So it's a considerable narrowing of at least how most of the industry understood the effect of the Court of Appeal's decision. Briefly, just a couple of other points, and then I really should hand over. There have been a couple of other sanctions cases in the last 12 months. I'm sure a lot of people in this room will be familiar with the MUR and RTI case. That was the case about whether or not an obligation to receive payment in US dollars, and when there was a force majeure clause, the party who was receiving money could effectively be forced or required to accept payment in euros instead. That case is going to the Supreme Court. James Shirley of Chambers, who was here and promised he would stay if I gave him a shout-out, but I don't know if he stayed true to his word. He's got that case in the Supreme Court in March 2024, so watch this space. One other case, which was on a similar line and gives an idea into the thinking of the courts, was Gravelor. It's a case that myself and Andrew Lungren was involved in. Bareboat charter. Owners were a sanctioned target. There was a clause in the charter that says if payment can't be made to the owners because the owner becomes a sanctioned target, and the parties have to cooperate to resume payments. The charter said, well, we think this means you have to nominate a euro account in the EU into which the sums will be frozen when we pay them. The owner said, no, I'm not going to do that because I'm not going to be able to get the money, and that doesn't feel like cooperation to me. The court, and it was Mr. Justice Foxton again, they held, no, you have to do that under the clause. You have to nominate an account and you have to accept payment even though it will be frozen. And I won't, because of time, get into the nuts and bolts of that, but what both the MUR case and that other case, Gravelor, it's called, show that the court's approach to these kind of clauses is going to be to help the innocent non-sanctioned entity and allow them to resume performance, and also to construe them very narrowly, or at least against the sanctioned entity, to the extent that they're trying to use that as an excuse not to accept an alternative form of performance. So I think there'll probably be a consistent line, even if it's different clauses in subsequent cases.
Thanks very much, Chris. I'm going to be the third speaker, and that means that I can avoid any embarrassing quotes from Legal 500 and Chambers and Barnes.
That's simply not true. The best quote about Simon is that he is as smooth as marble and as polished as a guardsman's button. And in an uncharacteristic display of confirmation bias, he is sure that they're talking about his advocacy.
Yes, if the person who planted that quote in Legal 500 or Chambers and Partners is present, I'd be very grateful if they'd see me afterwards. Because otherwise it can be taken to refer to other aspects. So I'm going to talk about the giant ace, a decision in the Court of Appeal in which I appeared for the successful respondent, which is going to the Supreme Court in July of this year. Delivery of cargo at its destination without the production of bills of lading is a fact of everyday life. It's almost invariably accompanied by the issuance of a letter of indemnity, LOI, to cover the shipowner's potential liabilities if someone turns up out of the woodwork waiving the bill of lading and claiming for wrongful misdelivery. When the owner faces such a claim, can he rely, if the claim is made under a bill of lading which incorporates either the Hague Rules or the Hague-Visby Rules, upon the Article 3, Rule 6 time limit? Is it a claim which is caught by the Article 3, Rule 6 time limit? And as so often, I think, with Hague and Hague-Visby Rules cases, one would think the answer would have been pretty well settled by now, Hague Rules dating from 1924 and the Visby Protocol from 1968. But it's surprising how many cases show that there are still gaps. And for misdelivery liabilities and the application of Article 3, Rule 6, the journey has been a long one. Before 2018, there was a very strong school of thought that misdelivery, said with a sort of special tone of voice, i.e. delivery of goods without production of a bill of lading to a person not entitled to them, was so serious a breach of the contract of carriage that Article 3, Rule 6 could have no application to it at all. And that stemmed, I think, from fundamental breach type thinking, and there was a very powerful article written by Lord Mustard in 1971 after the Visby Protocol came in that said this has got nothing to do with misdelivery, which is always outside any contractual or statutory exemptions. That view was finally squashed in 2018 by the decision of David Foxton, QC, as he then was. He's getting a lot of mentions this morning, and for good reason, in the case of the Al-Hani. The Al-Hani was endorsed by the Court of Appeal in the giant ace. He held that Article 3, Rule 6 applied equally to misdelivery, so delivery without production of the bills of lading in contravention of the contract of carriage. Article 3, Rule 6 applied to that as to anything else. But the problem, as a sort of way step on this journey to get a solution, is that the Al-Hani was a tanker case, and therefore delivery took place simultaneously with discharge at the flange. It was an STS transfer. And so whether misdelivery occurring on discharge was decided, but whether misdelivery occurring after discharge, which in dry trades is by far the most common case, was left undecided. And David Foxton made it quite plain that he was not deciding that point. But the point came up in the giant ace. And in the giant ace, the court had to grapple with the question directly because it was a pretty standard case. It's amazing that these cases haven't come up before. Cargo of coal, discharge into a stockpile controlled by the carrier, and then released from the stockpile by the carrier against an LOI without production of the bill of lading. Wrong party took delivery of the goods. The bank, who held the bills of lading, sued the owner for wrongful delivery, misdelivery. They sued out of time, just by a few days. And although they argued in the giant ace that the Article 3, Rule 6 time bar of 1 year did not apply, it's very different from their conduct because they strove very, very hard to issue in time. But unfortunately, they missed the bus, and there's a decision of Mrs. Justice Cockerell's on their unsuccessful application under Section 12 of the Arbitration Act for an extension. So the issue came up, can owners and carriers rely upon Article 3, Rule 6 in those very common facts? And the context of that debate, as it was in the debate in the Al-Hani, really turns on two provisions in the rules. Article 2, which is the same in the Hague and the Hague-Visby Rules, which says that under every contract of carriage of goods by sea, the carrier in relation to the loading, handling, stowage, carriage, custody, care and discharge, note the word discharge, is subject to the responsibilities and liabilities and entitled to the rights and immunities set out in the rules. That makes it look, therefore, as if the rules only apply to those operations. Under the Hague Rules, the time bar provision is worded, the carrier shall be discharged from all liability in respect of loss or damage. Wide words. And then these words, unless suit is brought 1 year after the delivery of the goods or the date when the goods should have been delivered. So instantly the difference being drawn between discharge and delivery, which are usually in very different stages, except possibly in liquid bulk trades, where things take place at the flange. Article 3, Rule 6 of the Hague-Visby Rules was much more widely worded. And it was much more widely worded because, as the Travo show, it was specifically addressed at misdelivery of goods without production of bills of lading. And the wording then is discharged from all liability whatsoever in respect of the goods, again running from delivery. So what were the arguments in the Giannaise? For the carrier, I argued that the Hague-Visby Rules applied because of the interpretation of the clause paramount, and therefore we were entitled to take advantage of the widened version of Article 3, Rule 6, and Article 3, Rule 6 on that wider version plainly applied, 1, to misdelivery, and 2, to misdelivery whenever it occurred, even after a discharge. Secondly, that if the Hague Rules applied, if we were wrong about the clause paramount, then even then the wording was wide enough to apply. We had a third string to our bow, that if Article 3, Rule 6 didn't apply under either set of rules, then there was an implied term of the bill of lading after discharge that the Hague Rules or Hague-Visby Rules would continue to apply until delivery, and we relied upon Lord Justice Longmore's statement in the MSc Amsterdam, where he said, no doubt if no agreement is made for the period after discharge, it might be easy to say that the parties have impliedly agreed that the rules continue, what came to be called in argument the Carver implied term, based on a statement in Carver on bills of lading. The bank, conversely, argued that the narrow wording of the Hague Rules applied and the Hague-Visby Rules did not apply, and that there was no basis for an implied term. So with these battle lines drawn, the rounds of battle were as follows. In round 1, there was an LMA arbitration before a tribunal of rare distinction, Sir Bernard Eder, Julia Dias KC, now Mrs. Justice Dias, and Tim Young KC, pretty powerful lot. They held that the Hague-Visby Rules applied, not the Hague Rules, so we were over that first hurdle. And they took a more holistic view that was that Article 3, Rule 6 covered, because one had to read the rules in a wide way as applying to the whole of the contract of carriage. The rules are inserted in the contract of carriage, which is in a bill of lading, which starts with acceptance and receipt of the goods by the carrier and ultimate delivery of the goods by the carrier. So we won. Round 2 was a Section 69 appeal to the Commercial Court. Leave to appeal on the clause paramount point was refused, so now we were only arguing about the Hague-Visby Rules, and Sir William Blair broadly agreed with the tribunal. But because of the interest of the point, and because of the linkage with the Al-Hani and the point left open, he gave permission to appeal. Round 3 was fought out last year in the Court of Appeal, in front of a very strong court, Lord Justice Mayles, Lord Justice Popplewell, and Lord Justice Nugee, and we were successful on behalf of the carrier. But the argument and the reasoning of the Court of Appeal is very important to notice. And they took it in a number of stages. First stage was they looked at the unamended Hague Rules and asked, did Article 3, Rule 6 of the Hague Rules apply to post-delivery, post-discharge misdelivery? And they said no, because for the court, the decisive question was irrespective of the wide words of Article 3, Rule 6, its purpose as a comprehensive time bar, see cases like the Captain Gregos to allow the shipowner to clear his books completely. The better view was that the words in Article 2 governed, and therefore the Article 3, Rule 6 time bar could only apply up to discharge, but not after discharge. So far, so bad, at least for us. But the second stage in the reasoning was they asked themselves whether the widened wording in Article 3, Rule 6 of the Hague-Visby Rules produced a different result. And the Court of Appeal held that they did produce a different result. So Article 3, Rule 6 of the Hague-Visby Rules does cover misdelivery occurring at any stage, including after discharge. And they reached that result for two reasons. First, because they said the language was so wide, all liability whatsoever in respect of the goods, that it must have been intended to create a different result from Article 3, Rule 6 of the old Hague Rules. But secondly, and importantly, they looked at the Travo. Now, I've argued Travo cases a lot in the Hague Rules. It's usually pretty a fruitless task because you can find something for everybody in Professor Berlingeri's book. But for the Visby Protocol, it's different because the Visby Protocol set out a menu of things they wanted to address specifically and then ticked them off. And one of the things they specifically wanted to address was misdelivery without production of bills of lading. And that was plainly a target, and that's why the wording was expanded. The Court of Appeal said that couldn't possibly be read as applying only to misdelivery on discharge and not after discharge, when most misdelivery cases occur after discharge. They didn't need to comment on the Carver implied term, but they weren't very polite about that, and I think the editors of Carver are already revising the book. If I were them, I'd tell them to hold their horses, because that's going to the Supreme Court as well in July of this year. So round 4 is going to be in the Supreme Court in July of this year, and I think the really interesting question is going to be whether this dichotomy which now exists between Article 3, Rule 6 of the Hague Rules doesn't apply to misdelivery after discharge, doesn't apply after discharge at all, and Article 3, Rule 6 of the Hague-Visby Rules does apply after discharge and does apply to misdelivery after discharge, is going to be evened up. And in which way is it going to be evened up? Are we going to go back to a restrictive approach, only up to discharge, or are we going to do a wider approach under both sets of rules with the coverage of Article 3, Rule 6 applying up to delivery? And so this year, the long journey from fundamental breach, Lord Mustill in the 1970s, the Al-Hani in 2018, the decision of the Court of Appeal last year in 2023 will end, and we will have a clear answer from the Supreme Court one way or the other on what Article 3, Rule 6 will say. I'm not going to venture any view, because I'm going to be arguing it for the respondent, but because I know that people on both sides are in the room, but so it will be a case of watch this space. Thank you very much. So from misdelivery and time bar to misdelivery and whether misdelivery has actually caused any loss. What's striking about 2023, there are 2 Court of Appeal cases which are dealing with misdelivery or delivery of goods without production of bills of lading. And the second Court of Appeal decision was in the Siena, which grappled with the paradox that if anyone had asked the person holding the bill of lading, can the goods be delivered without production of the bill and against an LOI, the holder would probably have said yes. How can the holder in those circumstances turn around and say, I've suffered a loss for something he would have consented to? Paul Toms, shortly as I say, to be Paul Toms KC, always good to plug that again, described in the directories as an incredibly fluent advocate with a tenacious approach. I hope not, because I'm against him in the Court of Appeal in May. Was junior counsel for the successful appellant with Rob Thomas, of Quadrant, who sits in the front there, and he's going to give us an insight into the case. Paul, is the case really so important, or does it just turn on very special facts and can be put into a cupboard?
Well, as I'll explain as I take you through the facts and the judgment, it seems to me the causation part of the case, which is, I think, certainly the part of the case where bill of lading holders will want to put very much into a cupboard of special facts, is one that is potentially capable of wider application with quite significant implications. But if I could just take us back to the beginning and first of all explain why the case is of interest and importance. There were 2 strands to the judgment, as many of you will know. The first strand is that it's the first time that the English courts have rationalised the basis of the so-called mere receipt rule, which concerns the contractual status of the bill. And secondly, and as I think is going to be more important, it addresses the question of causation. How do you approach that in misdelivery cases? So just a quick recap of the facts to ground us. The ship owners Euronav concluded a charter party with BP under which they were obliged to deliver against an LOI if ordered to do so. The bill was issued to BP as shippers. BP in turn sold the cargo to Gulf Petrochem, with payment being made by way of a letter of credit, which had been issued by UniCredit as Gulf Petrochem's financier. Importantly, the financial arrangement between UniCredit and Gulf was that the bill of lading was not to be used to obtain delivery of the cargo. The cargo was to be delivered by Gulf to various off-takers whom had been approved by UniCredit. Those off-takers were to pay for the cargo on extended credit terms, and payment was to be made direct to UniCredit for the purpose of repaying the finance. Subsequent to the payment of the sale price, the charter party was novated such that Gulf Petrochem replaced BP as the charterer. The novation agreement, however, did not address the status of the bill of lading, which remained in BP's hands, despite the fact it had no ongoing interest in the cargo. Gulf gave orders to the ship owners to discharge without production of the bill. Those orders were complied with. No payment having been received by UniCredit from the off-takers, there was, by that stage, news of a widespread fraud by Gulf Petrochem in the market. Eventually, the bill of lading was received by UniCredit, endorsed to it, and they brought a claim against Euronav for damages under the bill. So the two principal questions for the courts were, firstly, was there a bill of lading contract at any material time, given that possession of the bill had remained with BP up to and including the time of delivery? It was argued by Euronav that at the time of delivery, the only contract was the CP, and that mandated discharge to be made without a bill of lading upon the charterer's instructions, which was done such that there was no breach at all. Alternatively, if there was a bill of lading contract, did the breach of that contract cause any loss? So dealing first with the contractual status of the bill, at first instance, Mrs. Justice Mulder held that the bill, upon its issuance, was a mere receipt because of the co-identity of the shipper and the charterer at that time, such that the contractual relations were set out in the charter party and not the bill. That much was uncontroversial. However, the question arose as to whether the subsequent novation of the charter party by BP to Gulf made a difference. Did a bill arise at that point? What she said, in essence, was that no contract on the terms of the bill arose at that stage was because it was perverse to infer the creation of contractual rights in a document, namely the bill, which previously had had no contractual status between the parties, from an agreement, namely the novation agreement, in which the existing contractual relations were terminated. That part of the judgment was successfully overturned on appeal. Whilst the question was novel, the Court of Appeal framed its analysis by reference to general principles which would apply to the contractual status of a bill in all situations. In essence, the question was, what was the presumed intention of the parties at the time that the bill was issued as to its contractual status? To which the answer was given that the bill of lading will, in general terms, be a contract, save only for so long as the holder is a charterer. That is the presumed intention, but in the usual way, that is capable of being displaced by contrary express agreement or where the circumstances demonstrate a contrary intention. In any event, the Court of Appeal also held that the effect of Section 2.1 of the Carriage of Goods by Sea Act meant that even if the bill of lading wasn't a contract at the time of delivery, the subsequent endorsement by BP to UniCredit retrospectively created a contract on the terms of the bill of lading such that there was a breach on that basis in any event. It therefore was necessary to determine the causation question, namely, had that breach caused a loss? The Court of Appeal started by saying the approach taken by the first instance judge was correct, namely, it was not sufficient to conclude without more that in the absence of breach, the cargo would initially have remained on board the vessel. Rather, the courts have to then say, what would have happened next? In other words, what would have happened had a shipowner initially refused to deliver without production of the bill? As to that, there were certain factual findings that had been made addressing that counterfactual scenario, which was said to be to the effect that the shipowner would have sought instructions from UniCredit and that UniCredit would have instructed Euronav to discharge without production of the bill. Those findings in that counterfactual world are and were legally significant because it is possible to vary the terms of a bill of lading contract, just like any other contract, by express agreement. So the Court of Appeal upheld the judge's analysis that the breach did not cause any loss, because even if Euronav had performed its obligations by saying, no, we're not going to deliver without production of the bill, there would have been an insistence by the relevant party, UniCredit, that they do so, and that is what would have happened, such that the breach caused no loss. So then just picking up really Simon's questions as, is this a case on its facts? Well, very briefly on the contractual status, yes, it is a rare situation in my experience to have an ovation of a charter party, still less to have no provision then made as to the status of the bill. Difficult to envisage many other factual scenarios in which one has to debate the status of a bill of lading, but the court has now given us a clear and coherent basis for addressing those situations. I think much more interesting in terms of its wider implications is the causation issue. And it was argued by the bill of lading holder UniCredit that the analysis at first instance was such that effectively in any misdelivery case, a bill of lading holder would be subject to this causation defence being raised. Now, the Court of Appeal was sceptical of that and considered that the particular facts of this case were perhaps not usual, and that it included, for example, evidence that UniCredit had other forms of security which it was content to have recourse to. I wonder about that, and I also wonder about the other considerations that the court referred to. It's worth also referencing at this stage, once again, Mr. Justice Foxton. He has considered, and I think it's the only substantive consideration so far of this judgment, he's considered the Sienna in a completely different context, but a world in which counterfactual causation inquiries are in place in Rolls-Royce and Goodrich, and he's identified some particular aspects of the case which may limit its application. But the reason I wonder about it is that the current practice, certainly the usual practice, is for trade finance banks to have their cake and eat it. They want to advance finance on terms that they get the bill of lading, but they also want to do so on terms that the bill of lading is not going to be used to obtain delivery. But moreover, they need the goods to be delivered in order to be repaid. So in essence, there's no real traditional documentary title role that the bill is playing when trade finance banks are in control. So it seems to me it would be a rare case if you asked a trade finance bank, do you want delivery to be made when a bill of lading is not available? It would seem to me a rare case that they would say no, because it's a necessary parting of their financial structure that the bill isn't produced and the goods are delivered. So what may be the focus, I guess, going forward in these types of cases is, will the counterfactual inquiry have to consider whether the trade finance bank would impose conditions on this hypothetical delivery? So they may very well say, yes, of course you can deliver without production of the bill of lading, but you must deliver to X or Y or Z or A and B. So on the facts of our case, there were 6 approved off-takers to whom the finance bank had in effect agreed that delivery should be made. So we might have this world in which the courts are engaged in a counterfactual inquiry, something the parties never turn themselves to, involving considerations of what the counterfactual conditions may be, and of course what the ship owner would say in response counterfactually. They may say, no, we're not prepared to take on the risk of delivering to certain people. You need to do something more. But one final remark is to say that on the facts of our case, which may be unusual, the quantum that was sought on the basis of the value which would have been realised by UniCredit had they obtained the cargo and sold it. That necessarily involved them putting in evidence of counterfactual matters. Now, in a case where a claimant restricts itself to the market value of the cargo at the time of misdelivery, that kind of evidence would not typically be produced in these types of cases. It will be open in a ship owner in all cases, and no doubt any of us pleading it now will do so, to put the holder to proof that in the counterfactual world it would have insisted upon delivery. But unless that is already in play, it remains to be seen how much the court is going to allow a ship owner to obtain disclosure in respect to those matters, insist upon witnessing statement evidence, or whether that will be regarded as some form of fishing exercise, and that the burden on the holder in that case will be very slight. So I think the causation issue is going to be something that will be of interest and require careful consideration by the courts in the future.
Yes, I mean, I didn't understand why the Court of Appeal said that it was something that would rarely come up. rather like you, because as I understood Mrs. Justice Mulder's approach, it was a straightforward application of the but-for principle and working out what happens in the but-for counterfactual. The fact that it hasn't happened before doesn't mean it's not going to happen again. And I think that there are wider implications in that decision.
Absolutely. It was certainly her standard application of the but-for test. There was a lot of evidence about the counterfactual because of the way in which the quantum case was put. But when one puts it at its narrowest, it does seem to me, at least for a trade financing bank, for the reasons I've already explained, that invariably they are going to want the stuff, cargo off the ship as soon as possible without the bill being produced. And that is a general application. So as I say, the focus may become on the conditions that would be attached to that counterfactual consent.
Lovely. Thank you very much indeed. Fifth and last, we turn to regulation and the impact of net zero. And we'll be happy to know not the coils and toils of EEXI and CII, which we dealt with in our summer seminar, but this time ship recycling and shipbreaking and environmental conditions. And James Turner KC is going to deal with this for us. He's described in the directories as having an astonishing ability to perform under pressure, which is just as well because we've only got 10 minutes left, and to have a skill of making the complex simple and persuasive, which is also good because he's going to be discussing the Hong Kong Recycling Convention in force next year and how it interacts with the Basel Convention. If he can't make it clear, no one can. Thank you, James.
Thank you, Simon. Morning. 2023 wasn't just an interesting year for cases. Of course, on regulation generally, there were some important developments. The UK government finally published its vision as to how the emissions trading scheme is going to apply to UK shipping. Spoiler alert, not much. And we had the MEPC in the middle of the year, which really does set the scene for some proper development of transition into future fuels. But that's not what I came here to talk about. There are, as you know, two international regimes covering ship recycling. There is Basel, which has been in force for a very, very long time, and to which almost every country in the world is party, notably not including the United States. And there is Hong Kong, which has, at the last count, about 23 signatories. And although it's itself now quite long in the tooth, it's a 2009 convention, is still not in force. And for a long time, it was traditional when talking about the Hong Kong Convention to add a parenthesis if it ever enters into force, because it had a very complicated threshold that had to be satisfied. But satisfied it was in the middle of last year when Bangladesh signed up, and it will come into force in the middle of 2025. Later last year, Pakistan also signed up, so we now have all the major shipbuilding countries, so that's Turkey and the three subcontinental countries, outside China as signatories. China currently only recycles its own flag tonnage, so it tends to be left to one side in these analyses. Now, one of the important features of the whole scene is that these two conventions have very different approaches. Basel approaches ship any recycling on the basis of approvals. So the state of origin, the state of destination, and any transit state all have to approve the particular transit of waste from the person throwing it away to the person who's going to deal with it. The transmission of waste to and from non-parties is not allowed, so strictly speaking, you can't export your waste to the United States, and nor can it export its waste to anybody else. And there is also a thing called the Ban Amendment, which has been in force now coming up for 5 years, which prevents the transport of hazardous waste, which includes ships, from any OECD country, so EU broadly, and UK, to non-OECD countries, which include, of course, the three in the subcontinent. The approach of the Hong Kong Convention is completely different. It focuses on the flag state and on the state of recycling, the state where the recycling will take place. And only those two countries are really subject to its rules. So there's no right of refusal, for example, by a transit state to decline to accept the passage of the ship, as it were, through its harbour on the way to Alang. Now, just on the Hong Kong Convention, it comes as a surprise to some that it isn't enforced, because many Indian demolition yards in particular have sought and obtained Hong Kong Convention approval, which is effectively certification by classification societies that their facilities are compliant with the requirements of the Convention. There are now also some Bangladeshi yards which have obtained the same certification. As yet, as far as I know, none in Pakistan, but one can expect to see some movement in that direction pretty soon, because we're only 18 months away now from the Convention coming into force. Meanwhile, as you may be aware, Hong Kong also has a sort of before life in the form of the EU shipbuilding regulation. And the way that the EU has managed to reconcile the competing demands of Basel and the Hong Kong Convention is to say EU flag tonnage may only be recycled at a facility which is on the EU list of recycling facilities. And the UK has taken the same template for its own law. Now, all those facilities are in the EU, the UK, there's one in the US, go figure, and there are several in Turkey, but there are none in the subcontinent at the moment. And the EU is now having a think about what it will do now that the Hong Kong Convention itself is coming into force, and will the existing template remain in place? And whatever the EU does, what will the UK do in this post-Brexit nirvana that we now occupy? One of the challenges, though, is that the Basel Convention says very clearly that it can only be superseded, either generally or in a specific area, by another convention if that incoming convention offers the same level of environmental protection as Basel does. And the Conference of Parties at Basel has the last say about that. And there is a strong question mark as to whether the Hong Kong Convention, even when it is in force, will be enough to satisfy the Basel COP. And what this means, is likely to mean in practice, is that ship owners who are getting rid of their end-of-life ships will still have to consider very carefully whether they have to comply with both conventions and make sure they're satisfying the needs of both when they are sending their tonnage off for recycling. Don't forget, as I said, there are only currently about 23 or 24 signatories to the Hong Kong Convention. And it looks, I would say, I'd give it sort of 60-40 against that Basel will approve Hong Kong Convention as being offering a substantially similar equivalence of protection. Now, all of that sounds dry and uninteresting to us disputes lawyers, so I'll just throw three things out to you. The first is, every so often in our line of work, you have to decide what's the scrap value of a ship. Well, what the scrap value of a ship is will depend strongly on where it can be recycled, given where it now is. It's not simply a question of looking up the LDT prices in Alang, because it may not be allowed to go there. And if the ship owner allows its ship to go there, or indeed if an insurer insures a ship for a last trip from, say, Western Europe to Alang, you may find yourselves being visited by the authorities. And there are ship owners who have been sentenced to prison in some countries in Western Europe for doing just that. So that's point number one. Think carefully about where this ship can be recycled. Point number two is don't break the law, you'll go to prison. And point number three is to watch the regulatory space very closely. I have a much longer talk on ship recycling, which I'm fond of giving. And every time I have given it, something has changed in about the 2-week period before I give the talk. This is a very fast-moving field which is constantly in flux, which is one of the reasons it appeals to nerds like me. Thank you.
James, are we seeing any impact on ship-breaking contracts, standard forms and bespoke forms?
I think as a result of the incoming Hong Kong Convention, well, in a sense, yes, because one of the BIMCO standard forms, I think it's either recycle-con or dismantle-con, is very much premised on the Hong Kong Convention.
Not Basel.
Not Basel. I mean, Basel is a very awkward thing to apply to ships, and there was a debate in the early years of Basel as to whether it applied to ships at all. But it's now universally accepted that it does, and there are a lot of guidelines which apply mostly to recycling yards, which the Basel COP have issued. But it's awkward. One of the reasons it's awkward is, you're going to regret asking me this question.
Yes, I am.
One of the reasons is that under Basel and under the EU equivalent, which is the waste shipments regulation, as soon as you decide that you're going to recycle your ship, it becomes waste. And so wherever it is the state of origin, and wherever it's going to end up is the state of destination. So you're instantly into the need to comply with Basel. Anyway, I digressed. Thank you.
Not really. Thank you very much. Let's kill that call. Thank you very much indeed, James. Before we take any questions, can I just point out, I think someone's dropped their mobile there, and they'll probably go away without it. So if someone could if anyone wants to ask a question, please raise your hand. The microphone will come round, and if you could identify who you are and where you come from so that everyone in the audience knows who's putting the question. We've got two hands. We'll go with that one first, and we'll come back to you in just a moment. Thank you very much.
Good morning, everybody. Robert Veal, Winter & Co. Solicitors.
Can you just raise your voice a bit more? Thank you.
I think that might be a bit better.
That's better, thank you.
I want to thank all the panellists for their presentations, which were very clear. My question, though, is to Nigel Cooper KC. Nigel, one of the subtle but noticeable changes in the wording of the 2013 Con Wartime Clause is on the specific point of the likelihood of the vessel's exposure to a war risk. And I just wanted to get your view on to what extent that really makes a substantial difference, or to put the question slightly differently, to what extent does the guidance we have in the Triton Lark, which I think is on the 93 form, to what extent can we actually carry that forward to cases on the 2013 Con Wartime provision? Thank you.
Happily, I'd looked over your questions at the previous session and noted that one. So I think there are two. The answer to that breaks down into two parts. The first is it's still slightly unclear to me why those who are responsible for the drafting of Con Wartime 2013 think that the new wording makes a difference. And just to explain the background to this, in the Triton Lark, you're quite right, Mr. Justice Tier was looking at the 1993, I think it was, wording of Con Wartime, which required the master to assess the risks to which the vessel may be or is likely to be exposed. And the view was taken that the words "is likely to be exposed" required too much of a speculative assessment of what the level of risk is, rather than looking at a factual analysis of what the risk is. And so the words "or is likely" is likely to be to which the vessel is likely to be exposed were taken out of Con Wartime 2013. And the view in the explanatory note is that this refers therefore only to a factual inquiry as to what the level of risk is at the time of the master's inquiries. It seems to me there are two difficulties with this. The first is that Mr. Justice Tier expressly found that the words "may be" and the words "is likely to be" mean the same thing. So therefore one hasn't actually, it seems to me, on Mr. Justice Tier's analysis, changed anything by the wording in Con Wartime 2013. The second is that actually, if you're trying to assess what, as a matter of fact, what risks might the vessel be exposed to, and what risks is it likely that the vessel will be exposed to. I struggle, although I'm sure there will be experts who can identify a difference, but I struggle to see factually what likely difference the different questions are likely to lead to. If there is in fact a risk, that's a risk the vessel is likely to be exposed to, it seems to me. And I just think that you can't put too much. I just think you can't put too much nuance on these things. At the end of the day, you're being asked to assess what a master sitting in the middle of the Red Sea with a potential threat. What view is he supposed to take of that risk? Not what are a panel of lawyers going to think when the question comes to court 3 or 4 years later. You have got to keep an eye on the practicalities of these situations.
Thank you very much again.
Could you stand up and identify yourself? Thanks very much. Everyone can see you. Thank you.
Thanks. Miriam Golby from Queen Mary, University of London. Thank you very much for all the presentations. My question was also to Nigel Cooper, sorry.
Well, he said he was quick on his feet, apparently.
I'm dancing hard here.
So the question is one relating to your comment about the way the decision to reroute the ship is taken. For example, whether the master was consulted, whether there was a genuine consideration of the risks that particular ship is exposed to. And I wondered whether that could have any bearing on the decision whether to imply a good faith term into the contract, as in that decision is one that needs to be taken in good faith, pursuant to a reasonable consideration of the risks.
Well, that is the reason you have to make those inquiries, and it goes back to the decision in the Product Star in the Court of Appeal, where looking at a piracy question rather than a war risk question, they identified 3 questions that you had to ask in determining whether or not the master and the owner was reasonably entitled to refuse the orders. And one question that you had to ask was the decision to refuse the orders taken in good faith? And in that case, one of the reasons, they didn't quite go so far as to say that the owners hadn't acted in good faith, although they hinted at it, but they certainly said the decision wasn't reasonable. And the factors that they looked at was that the decision in that case was taken by the owners without any, what one might call, contemporaneous analysis of the risks. So they hadn't spoken to the master. They hadn't spoken to local agents. They'd just taken the decision. And that is relevant both to the question of reasonableness, but also to the question of good faith.
It's always struck me as odd that the master's opinion is of very much importance. When there's a weather situation, you can understand the master's the man on the ground and able to judge the situation. When he's judging the likelihood of geopolitical risk and what the Houthi strikes are actually really doing, and whether their bulletin that they're only going to hit Israeli ships or Israeli control ships really marries up with what's actually happening worldwide, it strikes me the master's opinion isn't going to be worth very much. It's rather the owner's opinion that's going to be worth more.
Well, I think it's the context of the two, isn't it? That if you're an owner, if you can say, well, I've spoken to my master, and the conversation between the vessels in the area is that these are their concerns, then that is an added layer of evidence. But I agree with you. If you're talking about more generally what is going on the geo. But in a sense, that comes back to the present situation. We all know what the pronouncements are. We all know what is appearing in the media. But what is also clear is that on the ground, who actually is getting attacked may not actually bear too much resemblance to what's in the announcements.
Yeah. Thank you very much. Any other further questions? Sure. Any more? Yes, one more. Thank you very much.
Sorry, Sebastian from Werkbank Rhein, and apologies that it's another war risk one.
Well, I'm sure I've got 4 colleagues who can chip in as well as I
said it was on everyone's lips, and it is.
I was just wondering if you've had any proper look at the question of when you might be said to have waived the right to rely on convert time, say after you've sailed into the Mediterranean and then the decision is taken to divert around?
I'd hesitate to say that I've taken a proper look at the question of waiver in that context. I think actually it's going to be intrinsically linked to the contractual, to the question of what are your trading areas. I can see an argument that if at a certain date you sail into the area, you accept the orders, and you sail into the area knowing what the present risks are, and at the time you haven't invoked your rights under, the owner hasn't invoked their rights under convoy time, there is an argument that by sailing into the waters they've accepted the level of that particular level of risk. It's definitely got argument. It's definitely got points in its favour. I think in reality, though, if somebody's sailed into the area and suddenly changes their mind, I mean, first of all, you'd raise the question of good faith again. Why have they suddenly changed their minds, having accepted the orders? But if I was advising the owners in that context, I'd certainly be saying, well, if you're now going to change your mind, having accepted those orders, let's have some evidence in our pocket to show what's changed. Not necessarily why the risk has escalated, but what's changed. What's made, and in answering that question, you have to keep in mind that you have to always answer the question by reference to the particular vessel. So, for example, it's no use saying, well, the threat's got more serious for vessels that are linked to Israeli ownership if your vessel has no connection to Israel, because the risk for your particular vessel probably hasn't changed. You have to try and find the factors that are going to enable you to say that the risk has changed.
Yeah, I think there's a difference, isn't there, between receiving an order, please proceed to Singapore via Suez, and you're at Gibraltar waiting for orders, and you say, yes, I accept, or no, I do not accept because I assess the risk of a Suez transit and it's too dangerous and I'm not going. That's quite a straightforward situation, I think. But when you say, against a situation of risk, let's assume the order is given today, and the owner says, yes, I accept that order, and sets sail from Gibraltar towards Suez, and then halfway across the Mediterranean decides to change his mind, I think there are potential problems at least, with waiver, or putting it a different way, how are you now able to make a reasonable decision? What are you going to be able to point to be the changes between what was present for accepting the order and what is now present when you are saying the order can no longer be complied with? I think there are interesting questions there. Yeah. Anybody got any other views on that?
I'll just make the general comment that most cases turn on the evidence.
Well, there we are, ladies and gentlemen. You heard it first here.
Yes.
Any further questions? Okay, thank you very much indeed. Can I ask you, please, to give a round of applause to our speakers, not me, I'm just the chair.